Lyric Armstrong, real estate agent and advocate. Here we are still in Lenawee Court dealing with the D. Warner trial. I don't know if I did this the last couple of videos, so just want to go back and remind you that this has some DV activity, some sensitive material that could come up. It kind of comes and goes. It's not real descriptive completely, but if this is something that's just too much for you, please go ahead, click a different video. We got a lot of things going, landlord, tenant court, check out any one of those videos, and that will keep it a little simpler for you. And there's other probate videos that we have from different probate courts that are not related to D. Warner, so you can check those out as well. We're back in court, same day, right? When you have multiple concerns and issues on a matter, the court wants to maximize their calendar. So there's different things that will require timeline concerns, whether, if you got to respond or if you're going to have to deal with bringing in witnesses or whatever the situation, you may find it where there's some separation between one hearing versus another hearing. But this court has been pretty good at being collective in the hearing times so that you're getting a lot of the same information around the same time, and you're not spending a great deal of time reminding your honor, reminding the court of the things that happened months ago because it's, weeks ago, or maybe even as far back as last month, right? Well, this case was in court last week, so a lot of the facts are still fresh in everybody's minds. All right. I don't know what this hearing is on. The last hearing we saw Dale go to jail. That's what we did. Dale is in jail now, off to criminal contempt court, but we are back in court. So, we're just going to do our thing and go to court. All right, we're ready, Your Honor. We're ready for court. Remember, we keep it loud, so unplug or turn down your volume, whatever it takes to make sure that you are taking good care of your ears and you're not sacrificing your hearing. Additionally, make sure you like, share, and subscribe. Just a little housekeeping, nothing much. I like to keep it lightweight in that factor, all right? Like, share, subscribe, help others to be informed. This case is a high-profile case. This is the aspect of the case that is kind of avoiding much of the criminality concerns that the general public has. And I'm hoping, though, that the intrigue that the public has will help to educate them relative to probate matters, and that we all turn to a professional attorney to help us put together our will and our trust so that we can avoid most of the kerfuffle that's going on here. But under the circumstances of missing versus dead, who knows if we would be able to actually avoid all of it. But at the very least, we'll definitely be able to, you can put instructions as to what you want to happen with your business. If you're missing longer than a certain period of time, you can be creative and specific in your trust and in your will. So you can get business insurance, that if your partner becomes missing or is deceased, that you have an insurance payout that will pay out their heirs, so that you as a company are not responsible for forking over so much money at one time and then thereby, depleting the funds of the company. So we talked about that, other videos, go see it. But more importantly, talk to the professionals in your area and get the law that's relative to you in your state. Now,
852CA. All right, we're back on the record for the last matter that was scheduled for this morning.
yeah.
The objections to the inventory that was filed by the conservator. I have the names of our participants, please.
Good morning, Your Honor. John Polder on behalf of successor conservator Charles Bullock.
Good morning, Your Honor. Errol Berger here on behalf of D. Warner.
Morning, Your Honor. Suzanne Wilhelm Gardini.
So newbies to the scenario. Holderman here, he represents Charles Bullock. That's the conservator. He's the conservator who was like, I believe he's the one, because there was a couple conservators. So I believe he's the one who said there's something nefarious going on. Things are getting shifted around. Money is not looking the way it's supposed to. I still have expenses coming out of the old company, but yet there's no income all of a sudden. Then I heard that there's going to be a sale of something, and I'm not sure because Dale is not cooperative. So he's the one that kind of made everybody aware that something needs to go, needs to be investigated more in depthly. This is his attorney, in the sense that it's not like his personal attorney, but he's the attorney that's representing the conservator so that he can do the legal things that happen in the case. This lady that's standing up is the guardian ad litem for the young child who's around 11, 12 years old at this time. The lady that's came and sat down, that's Dee Warner's attorney, but not necessarily her personal business attorney that they've been like talking about in Dale Warner's defense. She's an attorney that probably was assigned as an attorney, I don't know, by the court or otherwise, but she became her attorney after her disappearance, just to legally fight for her rights. And then this gentleman is the guardian ad litem for Dee Warner. So guardian ad litems, and which are these two, they will speak to a lot of the emotional impact, or, you know, what are the living circumstances of children, or, you know, what the best interest is relative to scheduling. And, you know, if they feel that this house is a nice fit for them, that they're getting their nutrients and they're thriving, and they're making sure that they're getting all those social services, going to, what's it called? Therapy if need be, and so forth, and going to school and just whatever is needed. He is the guardian ad litem because Dee is quote unquote missing and or dead, right? Once they have the declaration of death decided upon, then he'll be able to call her dead from here forth out, if that's the finding of the court. But right now, he's in effect to say, no, it's not in Dee's best interest to close her business down, things like that. Even though she's an adult and she's not ever able to communicate with him because she's not in his presence, it's as if to say she's incapacitated by some measure. So you might have an elder person who is incapacitated and doesn't have the ability to make business decisions on their own any longer. They would get a guardian ad litem such as he, that would kind of make sure that the businesses are keep going forth, things that are relative to their best interests are going forth, or at least communicating to the attorneys in representation of that factor that there's a problem. She's not getting her medical care. She's not getting, you know, her therapy. The business is shut down. Now she doesn't have income. So that's why these two people are in existence, even though they're also attorneys that are in existence for their well-being. Dee's attorney was the petitioner, he left out. No, this is Dee's attorney, but there was a petitioner, and he's an attorney for the family, which are these family members here, and probably the young child as well. It's a total of 5 children. Okay, so I hope that helps to kind of set the scene for those who are new.
Guardian ad litem for Angelina Warner.
Michael McFarland, attorney guardian ad litem for Dee Warner.
Your Honor, I'm Larry Lee, Vice Chair on behalf of the Warner.
Thank you. All right, at our last juncture, Mr. McFarland, you were concerned you needed some time to review the objections and the supporting documents filed by Mr. Lee. Have you had that opportunity?
One moment, Your Honor. Consulting also with Ms. Wilhelm, we did not receive any special.
I believe the gentleman who just walked in, I believe he is the conservator Bullock. And the reason why I say that is because Bullock and Polderman have been on Zoom. So when they've come to court, they're usually on Zoom and they're in the little boxes. So that's what he looks like to me. Polderman has come to court physically once, but this guy here, I think is, I think that's Bullock. And it's funny because he just took the chair from the respondent's side because Dale is now put in jail. I mean, it's not funny, but it's funny to me. Sorry, I'm laughing. I'm human. I'm sorry. It's not good. I shouldn't be laughing, but I am.
Specificity, I believe is what this court was requesting today, was specificity on his objections. So I don't know how he proceeds without specificity. So that's my position. I'm sure Ms. Wilhelm will also mirror that.
Do you have any objections to the accounting?
I do not, Your Honor.
Ms. Wilhelm?
I do not have any objections to the county.
Ms. Berger?
Judge, I think the response that Mr. Polderman filed cleared up a lot of the questions that I had. And to be honest, there are some things that I just don't know how we value. If we value including debt or not including debt, either way, the number at the end remains the same. So it doesn't really matter in my perspective. So I have no objection.
So this case is regarding, this hearing is regarding the financial stability of what Dee Warner's inheritance would be, what she would be able, if she died on natural causes and things were done in the particular format necessary for preservation and so forth, what would her family get? And this gentleman here, the CPA here, who is the conservator to that effect, Mr. Bullock, he was like, I'm having a whole lot of problems with these numbers, right? So he's gone through a lot of auditing and a lot of findings. The $150,000, I thought it was 125, but I guess now they're saying it's $150,000. It was like up in the air. Where did it go? It was cash. It went nowhere. He was able to determine, in fact, it wasn't just an accounting error that this side presented with their CPA. It in fact was money that was spent, but not necessarily, identified in the proper manner. So Polderman has filed with the court. Here's the accounting. This is what it should have been. This is what it is, I believe, is what we're going through right now. And no one's objecting to the numbers or the accounting. So let's see what our favorite attorney has to say.
Mr. Lee?
Do you object? Of course.
We filed objections to the accounting. Mr. Polderman filed a response to our objections. In his response, he really didn't make many changes. I mean, I can go through what my objections were and what our findings were, if the court would like that, but.
If you'd like, this is your opportunity to do that.
Sure. Your Honor, after reviewing Mr. Polderman's response to our objections, I actually have a kind of a scorecard just for demonstrative purposes to go through where we are in terms.
Oh, we love demonstratives. Love it. Love demonstrative purposes. We love those documents and those things. Disclosure to anyone that's listening for the very first time. I have not been in agreement with this gentleman. He and I have not necessarily seen eye to eye. I have determined the reason is because for which side he is fighting for, and it's my own personal biases. So please do not judge him based upon my finding. I don't even know him. I don't even know him. Judge him for yourself.
Of the split, the court would like a copy of that. It's nothing surprising. This is just what we wrote in our objections. The court would get.
Any objections, counselors? For demonstrative purposes only.
I'm just gonna go through it.
No objection, Your Honor.
No objection.
Thank you.
Yeah, it doesn't go into evidence.
Your Honor, in reviewing the accounting, conservator's first accounting showed that the state was worth $13,300,000. If you go down through this laundry
13.
list of the various
What?
sections of the accounting, the equipment, there's an RV of $275,000, $95,700 was associated with Dale Warner. There's a third party involved to the tune of $323,200, Warring Farms, not the LLC, that would be the DBA, $134,000. Other disputed is $65,000. The total equipment removals from the accounting should be $892,900. We believe the conservator has overstated the evaluations. For instance, DDW Investments was never evaluated as a business, but they put $1,864,000. We're not sure how they came up with that number. Warring Farms LLC, $314,000. The residents at 2170 West Mug Road at $93,000, and Warring Farms Services LLC at $153,000. So we believe that the conservator has over.
Okay. Okay. I'm sorry. I know you're going to be yelling it. I don't want you to interrupt. Okay, but look. I don't know what's in the paperwork, but if they don't have a BBO or an appraisal on the residential property or the physical property or even the equipment property, then yeah, I would have objections to their accounting as well, because the accountant is not the appraiser. This is where you get real estate agents involved. So for all those, I'm a probate real estate specialist. I also have other specialties, but I'm certified as well as a probate real estate specialist. And this is where I would be able to get involved in this particular matter. If called upon the court, they would say, okay, we have real property involved. We need you to sell the property or to go through the evaluation process of what the property is worth before we give you the go ahead to sell. I'm surmising things is not the way they technically say it, but this is how it goes. Then I would go out, I'd get the real estate appraiser to appraise the property. I, as the agent, can do a BPO, which gives some kind of evaluation opinion, but it's not an appraisal. I still would go out and get the $700 paid out. I tell the administrator, go pay the $700 to the appraiser and have a valuation appraisal done for probate and get an official reporting. So that when the conservator says the real property is worth $1.3 million based on current market value, they're doing so not out of the thin air or looking on some unsubstantiated website that everyone likes to look at, but they're not here, not the professionals for which you think they are. It's because the actual professionals, which starts off with the real estate agent and includes the appraiser, has gone through and done some evaluation. So if his objection is based on the fact that there is no supportive evidence to say that the property is worth a certain dollar amount, I would take issue with that too. He and I can see eye to eye on that. It's very few things he and I see eye to eye on, but that one, I'll give it to him. I like that objection.
The 314,000.
So far.
The residents at 2170 West Monroe Road at 93,000, and War Egg Farms Services LLC at 153,000. So we believe that the conservator has overstated the valuations of 2,421,000. Your Honor,
Wait.
the Services LLC at 153,000. So we believe that the conservator has overstated the valuations of 2,421,000. Your Honor, as you continue to go down the sheet that I prepared, the unreordered mortgages, land contracts, and loans. There's the Bader McDonald land contracts for $4 million that's not been addressed. The Bader McDonald $100,000 land contract that has not been addressed. The SBA loan, which was $1.492 million. Equipment loans of $350,000. IRS lien of $105,000, which has been paid down or negotiated with the IRS from approximately $500,000 down to $100,000.
Oh my Lord. Oh my Lord. So this case has hearings that kind of parsmill some things. And here's one of the parsmills. So in the contempt case, the criminal contempt case, one of the defenses that Dale had was that we needed a whole new company because we needed to avoid the IRS taxation on the payroll taxes. It was so astronomical, so forth and so on. Then he had his witness. Oh, I forgot to say this in the last video. The judge said that he was very heated or animated or something as a witness because he was very spicy to the judge, so spicy to these individuals over here, the petitioner counsels and the guardian ad litem. He's very spicy to them in open court, making direct responses, combative things you're not supposed to do as a witness. So he got up there and said, oh, the company was in so much debt. It just was in so much debt. So we had to start a new company because he was there for Dale's purposes. A lot of his testimony kind of benefited the petitioners, but okay, he came for the purpose of Dale. Now, on this hearing, which is, I forgot what this hearing is. It's no longer the contempt. Oh, this is the hearing to find out valuation, right? To kind of determine the accounting of accounting of Dale, not Dale, D. The accounting evaluation of D's estate. This is what this hearing is in reference to. And he wants to say that the lien that the IRS had against the company was $105,000. This is a multi-million-dollar company. And as I said then, he now gets up here and says that this is what they did. You don't need to start a new company to avoid the IRS. As far as I'm concerned, you're not going to avoid it. You're going to pay them their money. But what you need to do is negotiate the repayment plan. See if what the amount that they're coming to is different than your records and try to find out why they're coming to such a difference. Work with them, but start off with the repayment plan, because by all means, you're not avoiding them. They're going to get their money. So he just now says in his closing, Your Honor, there's $105,000 and I didn't even, okay. The other thing was, I wasn't sure if he got the SBA loan, because I remember they said that there was an SBA loan, but I wasn't sure if he actually got it paid out, because between that and trying to get another loan, it was, I think, in the same time frame. And the other loan that he went to the bank with the document for power of attorney, they felt was a fraudulent document. So I didn't know if that froze up everything, but turns out SBA gave them 1.5 million, $1.492 million. So he got that money from the SBA. And you mean to tell me you didn't have the $105,000 for the IRS? And like I said, all you would be doing is doing a repayment plan. As far as I'm concerned, $105,000 for a multi-million-dollar business is more along the lines of reasonable. They may have been able to even negotiate that down a little further, just depending on what the documents are. But under all circumstances, you would be going through the repayment plan in any regards. I mean, I know $1 million companies right now that are doing repayment plans, because the payroll taxes they kick your butt as an owner of property. I mean, not property, owner of a business. It's those payroll taxes. So a lot of companies try to avoid them by 1099ing people. But if you now talk to your tax attorney, let your professional guide you and advise you, because if you turn around and make everyone a 1099 to try and avoid having payroll taxes, which maybe that was the problem with that company, I don't know. But if you try that, but yet you tell them what to do and when to be places, and they have to be there at a certain time, and then they're no longer a 1099. They're a W-2. And if you haven't been paying anything towards their taxes, then the IRS audits you, and then you get dinged like this, you get a lien on you. But I just think $105,000 is something that could be done through a payment plan, and that any attorney that says, oh, avoid that and start a whole new company, I don't see how that is a professional advice. I don't see the professional advice. So I'm sorry for the tangent, but to hear now, all of a sudden, that, oh, Your Honor, this accounting does not account for the SBA loan, doesn't account for the IRS lien. And yes, that's substantially different now, because yes, we've been making payments on it and we got a payment plan. You just killed the defense that didn't win, but you just killed the defense you were hollering up about last time you were up there talking about they have to get a new company together because the IRS money was so astronomical. There's nothing they could do but start up a whole new company. Sounds like what you should have been doing was making payments.
And from the unpaid DDW,
I'll take it back
5,000,
for you.
which has been paid down or negotiated with the IRS from approximately 500,000 down to 100,000. And from the unpaid.
Okay, so he said it was 500,000 down to 100,000. Okay, got you. But nonetheless, there was negotiations that were allowed to be done and a payment plan allowed to put in place. You don't avoid the IRS. You call them up and figure it out with them.
DDW investments, there's the PNC portion that we've talked a lot about at 200,000. So the unreordered mortgages, land contracts, and loans is approximately 6,247,000. The total reductions, as we see it, are $9,560,900. Revised for discussion purposes, $3,739,100. So the split, the real value, as we see it in this estate, is $1,869,550. That's my argument.
Mr. Polderman.
the $1,869,050 is what they proclaim is the value of the estate. Is that before or after you stole? So what about the $900,000 loan? Where does that equate in this 1.8 million? Is that in there or is that in addition to? Because last time, your client was found to have taken out a personal loan for over $900,000. So he took out half. Did he take out half? Did he take half of the business valuation? Is that what you're saying?
There's two documents that were filed with the court. One was a amended inventory and the other one was a accounting and a petition to allow the accounting. There's been no dispute really over the dollars and cents that have flowed in and out of the accounts. We're reduced today to continue to considering the valuation of various of these assets. I would just note that the inventory form, which is SCAO form PC 674, requires a value listing of the property without reduction for liens. So that's exactly what we did. We obtained appraisals, we obtained valuations, we attached those as exhibits, and we put down the values without the liens. And then if you go to the exhibit of the property without reduction for liens. So that's exactly what we did. We obtained appraisals, we obtained valuations, we attached those as exhibits, and we put down the values without the liens.
Guys, this is what irritates me about him. I guess all attorneys do it because you have to spend in the, you got to work with what you got, right? You got to help your clients out some kind of way. But this attorney got up there and was like, oh, their evaluations are so off. It's just built on nothing. And Polderman's like, look, we got it. We did the evaluations with the assistance of appraisals. We went through the proper process. So all that I was telling you about getting an appraisal, I was like, I have issue if you didn't do it. Polderman's like, we did that.
And then if you go to the accounting, that then pulls in the value from the inventory. And that's the number that you need, that you're required to start with. Itemized assets remaining at end of accounting period. I don't dispute that there's monies owed to Bader and McDonald. That's been front and center throughout this. I don't dispute there's money owed to the SBA or the IRS or PNC. Those are all well known. Those are broken. Some of those documents are also attached as exhibits, but we're supposed to show the total value of the property without reductions for liens, which is what we did. As far as if we want to argue over the value of DDW Investments or the residents at 2170 Munger, we attached our valuations. They're welcome to go get their own appraisals. But as far as allowing an accounting and an inventory, we've listed the assets that we're aware of. We've done some due diligence and obtained valuations on those and put those numbers down. And we also accounted for all of the money that's flown through the conservatorship estate. The values that were put down are a snapshot, right? Until there's different ways to value it. We could have liquidation value. We could have fair market value. We could have the present value. We could have the value at the time the conservator was appointed or the date of D. Warner's disappearance. So these are starting points. There's been, just because the court is accepting the inventory or the court is accepting the accounting, doesn't mean that it's also determinative of the value of these assets. They conceivably will be sold at some point, or there will be some sort of resolution as far as a buyout of the parties or a financial separation. And at that time, right, numbers will be exchanged. And there will be a valuation again at that time as far as what these are. But the fact that someone may disagree with the estimate of the value of an asset like an RV is not grounds for not accepting or not approving or not granting a petition to allow an inventory and accounting. If we were here today and someone said there's $10,000 missing from the bank account, I think that would be the subject or a rationale to disallow it in accounting, or tell the successor conservator to sharpen his pencil and go back through it and find the missing funds. That's simply not the case today. We do have a dispute over values. We've attached what we believe are reasonable values. The form provides for without reduction of liens. We understand and acknowledge there are liens. The list that Mr. Lee provided showing debts to Bader McDonald, SBA, IRS tax liens, and PNC, I can confirm those entities are indeed owed. I'm not sure the exact amount owed on the equipment. I know there is debt on the equipment. So it's really doesn't speak to the issue at hand, the fact that there is debt, and we're not necessarily disagreeing with the fact there's debt. We would ask that the court allow the petition to approve the first accounting of the successor conservator, as well as the amended inventory. And of course, the inventory could change. We are aware of some equipment that Dale Warner's father claims an interest in. That's not on here. We're going to need a determination as to the value of that and who owns it. A number of their other objections as far as dollar amounts reflected the fact that this inventory and accounting goes to the middle part of May. So it's kind of an odd cutoff date, but that's just the date that the accounting is due. So there's disbursements that happened after May that they were worried were not reflected, but the accounting is for the time period it is. It doesn't include anything before it, and it doesn't include anything after that. So I think we've been able to speak to and address any questions and concerns regarding monies in and out of the account. Thank you, Your Honor.
Has there been anything supplied to you from Mr. Lee or from Mr. Warner or any of his associates that would have contested the, for example, you said they can find their own estimate of value or appraisal on specific items. Was any of that information presented to you or to the conservator, if you know?
It was not. I went through their response, which is lengthy. I mean, it contains exhibits A through Z and then another 8 exhibits after that. I saw a phase 1 environmental. I saw an old appraisal from 2018, but I have not received any current documentation that would.
I'm sorry, we're in 2023. Didn't she go missing in 2021? Why are we looking at 2018? And let me tell you, as a real estate agent, property valuation in 2020 during the panorama went up. It went up a great deal. And in 2021, it went up even higher. Now we can argue why, but my professional opinion includes scarcity of inventory. And during 2020, everyone was scared about having people walk through their home and didn't want them to view it. And so, you know, real estate agents like myself, we got creative. We did virtual home showings, right? So we showed you the home virtually, and you got to get a feel of it that way. And then once you put in your offer was accepted, then you can come and do your appraisal and your walkthrough at that time. And that would be the first time you actually got into the house. So that it limited having big bulks of people coming through the house, causing problems or potential problems due to the health concerns that everyone in the world. All right. And guess what? We were essential workers. So we had to, people like, oh, they shut down. No. There was a great, lovely clause in our order in our state, what other people's states did, I don't know. But in our state, our governor said, attorneys or anyone that had billings with the transaction of real estate, which is title reps, escrow officers, real estate agents, real estate attorneys, all of those individuals are considered essential workers, and therefore they could continue to work during that time period. 2021, I don't know if we had the vaccination by then, but whatever, we had stimulus checks and PP loans and all kinds of other financials that people came up on. So they were paying things down and getting in place. And then if you had executives were buying real property and they were spending a great deal of it. And we had low interest rates, right? Low interest rates, what the government puts in place so that you will buy property. So during this time frame, property valuations were extremely high, most across the nation, compared to maybe the year before, okay? I'm not saying that everybody was dealing with the California numbers, because no, they weren't. Right now, we got a house that's worth $93,000 and another one that's worth $153,000. So we're not talking about $1 million homes in the sense of what may be so in California, but because of it where it's located, these could be, mansions for all I know. I don't know what the house looks like. So Haldeman has given a very great opinion. He says, I've had appraisals done during the time period that was given to us. The time period is a funky one. Like, it stops in the middle of April. So there's transactional things that happen at the beginning of at the end of the month, or at least after that factor that's not factored into this time period, as well as beforehand. So if I'm correct, the D went disappearing in 2021. I believe that's the year. I'm gonna find out. I'm gonna make sure. But if she did go disappearing in April 2021, then her valuation of her property would be towards the heightened valuation, not current day, because current day prices have gone down. Not necessarily the year or two before that, because 2020 was high, but 2021 was higher when it comes to valuations of property. So, okay, you want to pull out 2018? Was she missing in 2018? Why are we looking at a valuation of 2018? That would be a low ball at today's standards. Houses that are of the same condition that they were in 2018 are worth more now in 2023 than they were in 2018. So that's not an apples to apples comparison at all.
Contradict our valuations. I think there was one dispute over the value of a truck. They had submitted, I don't know if one person put in Blue Book value, and then it actually sold at auction for slightly less, but what it sold for at auction is what it sold for at auction. So other than perhaps with respect to a truck, I'm not seeing a contrary appraisal.
All right, just for the record, could you reflect, just a few of the documents that you used to establish the values?
Yes, we engaged Yo and Yo, who are CPAs as well as business evaluators. They provided a valuation of what they thought DDW Investments was worth, as well as Warag Farms. I also engaged Maidema Appraisals, and they came out to the farm to value equipment. I invited either Mr. Warner or Mr. Weisberg to be present at that time. They were not, but we were given access to the various barns, and photographs were taken and an evaluation was put together. As far as the real estate, we engaged the company is called People's Company. They had done an appraisal actually back in 2018 in connection with the financial problems that the farm was experiencing at that time. They came out and did an on-site appraisal. Mr. Warner did not allow us into his home on 2170 Munger Road. The doors were locked. He was not present.
Yeah.
And I was told he was not going to be granting access. So the appraiser did an outside inspection and did a valuation based on the outside condition of the home. Once again, Mr. Warner and Mr. Weisberg were invited to be present. They were not, but that appraisal was conducted, and also by the same person that had appraised the property back in 2018. It included some additional parcels that were owned jointly by Dale and Dee, and I provided that to Mr. Lee as well. So really, we had three different professionals provide valuations of the real estate, of the equipment, and of the businesses. I do not believe we obtained a business for Warag Farms because that's a spraying company and doesn't do much in the way of business. And the other entities are the equipment holding companies, so they don't have any value really beyond the equipment that's owned. So hence a valuation of the equipment would capture that. Since this has been done, and really over the past 60 days, I've come to learn that there's 6 or 7 additional pieces of equipment that are parked on various people's property. So I had to take the deposition of Dale Warner's father, who said that there's a bulldozer and there's an excavator and some other odds and ends that he and Dale both used. He claims he thought Dale owns it. Dale claims he owns it, which is kind of convoluted, but something else that we'll have to chase down. The equipment has been identified, so we're aware of it, but point being, there may be some additional changes to the equipment as far as additions to it. And valuations is because we simply, a year in are still discovering there's some stuff out there.
Would you like an opportunity to further respond?
Yeah, just briefly, Your Honor, I appreciate.
Before he gets into his stuff, because y'all know I ain't trusting him no more. I'm not trusting him. I thought he had a great objection, and now I realize it's just fast and loose, and he's just lying and whatever. So I was right. She has gone missing April 25th, 2021. So the 2018 evaluation is mute. It is 3 years difference from even when she went missing. So its valuation in 2018 is not more substantiated than it would have been in 2021. It is most definitely, I'm willing to put some money on it, does not equate to the true value that it would have in 2023 during this time frame. Just doesn't. Our home valuation across the country has gone up. It's part of the concerns that I have as an advocate that I'm, working with my team on is like, how do we get home ownership to rise for our people when we're talking about little bitty homes selling for $1 million as a beginning price point? It's a hard thing to overcome. And so there's different ways that we're working on fixing it. So I know for a fact, home valuations have gone up. Okay, they've gone up. Maybe not a whole lot. It could be $5,000 difference. But nonetheless, even if they went down, let's just say they went down in Michigan. Maybe Michigan's not doing too well because of the Flint water crisis. Let's just say their property values are going down. Okay, fine. The 2018 appraisal is too old. And now I see why he's trying to attack the appraisal, because he's saying it's not a full appraisal, because it's probably not. It might be done by an appraiser. It's seldom that the appraisers would do this, but they would do it for the probate matter. They're not going to do it for the sale of a house. They're going to want entry for the sale of a house. But agents, such as myself, we don't have to have gained access to a house to do an opinion pricing. And that's what the BPO is. It's based upon our professional opinion in the business of real estate. So you have to be a licensed real estate agent in order to conduct that particular opinion. And then you have to substantiate it with the comps of your area and so forth and so on. It's a process, so it's not as simple as it sounds, but it is the lower valuation point relative to what can stand up in court, because it's an opinion by a licensed professional, whereas an appraisal, though it's an opinion, but it's the actual appraised value by the appraisal who is a licensed profession to appraise. So he may be attacking it because he's playing fast and loose with the fact that it's a BPO and not an appraisal, but his client wouldn't give him access to the house. So, you're preventing evidence at this point. And all that hoopla about we've been so cooperative. I haven't found a cooperative place yet. You're not cooperating with the valuation. You're not cooperating with the access. You're moving money around. You're starting up whole new companies. You're moving equipment around. You got it sitting on someone else's property to pretend like it's theirs. There doesn't seem any cooperation whatsoever coming from Dale Warner's side, in my opinion.
Appreciate the fact that Mr. Polderman acknowledges that the accounting was prepared without regard to the fact that there are liens and there are monies owed that have not been adjusted in there. I also understand that he did have an evaluation from the land from 2018.
Why are they not arguing the SBA loan if the SBA loan was the loan that he got after the fact? There were so many hearings about, well, did D. Warner sign that SBA loan? It's like, I don't know. And the detective said, I don't know who signed the SBA loan, but I can guarantee you that it was not D. Warner who signed the SBA loan. So unless Dale is given that type of power of attorney, because the one we saw was hocus pocus in my reading. But unless Dale got power of attorney to operate the business in Dee's stead, you know, in her absence, if she's out of town or whatever, I don't understand how the SBA loan would be deemed a lien and a liability of the organization if that was fraudulently gotten from Dale, by Dale, for Dale. I would think that would be his personal expense, but whatever. They can argue that at another day. All right, let's go back.
If there are liens and there are monies owed that have not been adjusted in there. I also understand that he did have an evaluation from the land from 2018. He used his own evaluation to compare to that. There were other things. Mr. Polderman has been given complete access to anything he has needed in order to properly do this account. I mean, we provided, I know the court has rendered an opinion otherwise, but we have gone above and beyond providing both conservators access to anything and everything that they wanted. Mr. Dempsey testified very eloquently, I thought, that he was given quick book downloads back in September and October of last year. He was given access to everything that he needed to do in order to prepare his own inventory. And when he resigned in March, was still in the process of preparing that inventory. So, you know, we went through the accounting now that we've been in this case 2 years. We believe that what we objected to was appropriate. Mr. Polderman acknowledged that there's no account. He has accounted for the fact that there are liens and will adjust it, I'm sure, at some point down the road. And that's simply our objection. I mean, our view of this is that the split should be 1.85, 1,800,000, sorry, $1,869,550.
Anything else, counselors?
Okay, he's gonna make me break my computer. I swear he is. He's gonna drive me absolutely insane. If I remember correct, the first conservator that was on the case was like, I'm not getting everything I need, and this is too far more complicated than I'm used to. I'm not qualified to go this deep, because there is an accounting process and then there's a forensic accounting process, right? And so he's like, I can put the accounting side, but then he's getting roadblocks or he's finding disparaging things and items are not accounting for properly. So he's like, I need to bow out because I don't do forensics. I could have sworn that's the way it happened, that Bullock ended up getting into it, because he's like, no, I can find the money. I'm gonna find this money. Because one of the things that they had before was like, it's 150K, I just don't know where it is. So that's a rounding error. And it's like, no, we're gonna get somebody else to come up here and find out. And Bullock is like, no, it's not a rounding error. This money was spent. That's what it is. It's gone. It was spent and not earmarked and done properly. So let's see what else I got to say, because he works my nerves.
I have nothing,
Wrong.
Your Honor.
My mind has not changed. I'm still okay with the accounting.
Mine has not changed.
Well, thank you. The court has reviewed the accounting, the amended inventory, the objections, and listened carefully to the responses. And I appreciate the attorneys. Thank you, Mr. Lee, for this breakdown. This is this is a nice snapshot, a way to look at the issues that you would like me to look at. The court, as well as Mr. Polderman, does acknowledge that requirements for providing an accounting may not always adequately reflect the amount of debt currently associated with the assets. But nevertheless, we must follow the law and the rules that govern accounting. And I do not see how the accounting or the inventory that was prepared would violate those terms and conditions. I can understand the reservations, and those have been acknowledged by Mr. Polderman. As far as the debts go and some of the things that were concerns raised by Mr. Lee, but I agree that they do not prevent the court from approving the first inventory, I'm sorry, the amended inventory and the first annual accounting. I would also note that, for example, the appraisals and some of the ways that the valuations were conducted are very recent. And in fact, using the same appraiser that did the 2018 appraisal on the real estate, that seems like a very good way, frankly, to ensure continuity and fluctuations in value, for example. So it will be the order of the court that the amended inventory and the first amended accounting are approved. Understanding that, of course, that's a snapshot and things will continue to evolve and through discovery as well, it sounds like. Unless there's anything else, I believe that's all for this morning.
Will the court enter its own order on that, or should I prepare one, or you just sign the?
I don't have the, typically I have a proposed order to that effect on one of the SCAO approved forms, but if you'd like to submit that, I'd appreciate it.
All right, thank you, Your Honor.
Anything else?
None further, Judge, thank you.
Thank you. Thank you, everyone. That's all for today.
Thank you, Your Honor.
Okay, are you surprised? Put it in the comment section. Are you surprised? No, of course not. Why would we be surprised? Why would we be surprised at this particular stage of it all? Let me give you a little. Let's get some fun. Let's have a little fun for a second because this is heavy. So you see me like cut it down real quick because I want you guys to be like all into this. I don't know what this bombshell stuff is. I ain't got nothing to do with Demi Moore. It makes me no difference. But this is one of my favorite YouTubers, Emily D. Baker. I watch her a great deal. Oh, she's live. Okay. Different hearing matter. And then Wildin' Out. Okay. So if you're not watching and look, we got a zoning violation. That's not, we gotta get into Judge Middleton's court. We gotta get into Judge Middleton's court. Yes, zoning violations. This is our thing, real estate. We love it, right? And then I watch Wildin' Out a lot, which drives a lot of people crazy in my house. So I'm always plugging into it because you just need to laugh. You gotta laugh sometimes, and things like this case are sad and they can wear you down. And it's not even your particular set of facts. It's not even your circumstances. So you have all the financial concerns of your own life and the children concerns and the marital spousal concerns and the business concerns and whatever you're doing with yourself and your loved ones. We all have something. Everybody has something that goes on at some point. So I just want to say, find yourself something funny. Wildin' Out does it for me. Maybe that's not yours. Find your favorite comedian. Find your outlet so that when you're watching something negative, you can laugh by watching something funny, okay? Go watch something funny. I want you to take care of yourselves. Mental health, physical health, they're very important. Emotional health, very important. So do what you can to keep yourselves whole. I encourage you on that. All righty. What did we talk about? We talked about money, but this is not the money that relates to Dale's payback, okay? So this is not how much will Dale have to pay back based on the fact that he went to jail in the last hearing. That particular restitution is based upon the money that he moved around. So they're gonna have to do an accounting on what money did he move around and what did he cost them relative to having two conservators trying to jump through hoops to figure out what the money was that he was moving, because he wasn't upfront about it at all. He just wasn't upfront. So Attorney Todd Flood, I don't know who that is. I'm looking for right now. I want to know, which I should go to Google. Sorry, I'm not sponsored by these people. Just want you to know I'm not sponsored by them. But boy, I've got to go by the right place. Okay, so what attorney is representing Bill Warner in probate court? He has a name that is not, um, Governor from Oklahoma. They're not in Oklahoma. This is Lena Way. Way, courthouse. So I was gonna look up his attorney, but they, of course, are giving me all the other salacious things and bringing up the case and talking about Dee's disappearance. So I'll do that later and tell you what I find out, because I want to know is if he is on the court, if he's on the case in the probate court in preservation of the criminal concerns, because a lot of his representations really worked to protect him on the criminal side. Like, oh, we don't know that she's dead, but we don't know if she's murdered. You know, she's dead, but he didn't do it. You know, that kind of thing. And I'm glad he did it. I just wonder, like, what's his real background? Does he have a probate background or not? Because and I didn't even write down the form, but there's a probate form. There's a probate inventory form, which, you know, they went into the worksheet where you don't have to have the debt in order to do an inventory sheet and an accounting sheet. And that's what a probate attorney would know, but yet his objection was real relative to the fact that the inventory and appraisal of that was missing any liens. And like we talked about during the closing arguments, you know, some of those liens, I wonder if they're really her liens, but whatever. Holderman, he didn't object to the SBA loan. He felt like, yes, that is a lien that's not accounted for, but we don't have to in order to inventory. And this is just the one. This is one, and there's probably going to be many more. And the reason being is because they don't have access to everything. So I'm not sure all of this. Oh, we've been cooperative with all of the conservators. Hogwash. That you didn't give them access to the house. So how do you expect for an appraisal of the house if you don't let them in? You're going to get the opinion appraisal. You're not going to get a full appraisal because you don't have the entry of inside the house. And a lot of times that's not just inside the house, because they got to go underneath, see what the plumbing's like underneath. They go on top, check out the roof, see if the roof is falling down or how the shingles are, if there's too many layers. And so if you're doing a BPO or just an opinionated appraisal, all you're doing is walking around the house or driving by the street. And you're taking a picture and you're appraising it with the hopes that at the best of appearance, if there's nothing wrong internally in the area of this location, this is how much it'd be worth. And then you say, well, if there are certain wear and tears that kind of present itself, because I see the windows are boarded up, I'm really concerned of its interior, because obviously there's something going on that's devaluing the house. Then you give the low ball as well. So you give them a range. You don't just give them one number. But an appraisal is like, look, this is what your house is worth, because they've looked at it. They've gone through it. They've seen it inside, on the top side and the bottom. And they didn't give access. So I don't even understand what they're talking about. So whatever. Like I said, he irritates me. So it could be me. It could be me. So you tell me, put it in the chat. What you think? What do you think? Tell me what you think. I want to hear from you. I think us having differences of opinion, or at least maybe being able to voice our opinion, is highly important because it allows us to think differently. I got some differences of opinion relative to if the tenant was playing games on on that video. We had some people that are like, yeah, of course he's playing games, and some people, well, maybe he's just thinking out loud, because, you know, when I got done with the video, I kind of felt like, well, you know, he might have a cognitive concern that really doesn't help him to understand fully and wholly, and that's why he's like teeter-tottering, but he was driving me crazy, child. Praise the Lord for Judge Simpson on that matter. And thank God for Judge Catherine on this matter, because as usual, she lets you say what you have to say. But when it comes down to putting her order in, it's in and she's done. And nope, court is in recess. That's it. All right. So this was the interesting day. We had D. Warner Day. We just call this D. Warner Day. Give our love, support. Please don't harass anyone, not even Dale. But give our love and our support to D. Warner, her children and family that they get through this time, because court is no fun for some people. Attorneys, it's fun because this is their playground. But when it comes down to going to court on matters such as this, it can be taxing. And I know I've been kind of hard on Dale's attorney, so love to him too. He's trying. He's doing his job. I mean, I guess we all got to do something, but I don't know that I agree with his methods or his objections, but he's definitely working at representing his client to the best of his ability. And so therefore, kudos to him for that, because one thing that is a good reminder is that you never want a defendant not to have good representation. This is why we pay for it if they can't afford it. You want a defendant to have the best representation. Murderers, rapists, whatever, fraudulent people, criminals, you want them to have the best defense, because when they found guilty, you don't want nothing to overturn that ruling. You don't want any appeal process to take it away. You don't want them to get away with it later because they are saying, I had ineffective assistance of counsel. So you want to make sure that the counselor is phenomenal and that they're doing a great job, so that when they lose, it's a done deal. That's how I see it. I support defense attorneys in criminal law. I would never practice that. I don't have any inclination for criminal law. I'm apropos to it. Probably, I'm opposed to it probably. So I don't find myself ever practicing that. I'll stay civil and real estate. I'll stay on this side of things, but I respect it. And I definitely respect that every defendant deserved the right to counsel. So he's doing his job. So kudos for that. He's got to work with what he has. So I know I've been very, critical. So excuse me, I'm sorry. Sorry for being so mean. Anyway, I'm Lyric Armstrong, your real estate agent and advocate. Like, share, and subscribe. Make this video go out and about, because we are learning things. We are learning great things about the process. This process in probate is letting you know that there's an inventory done. Guess what I said last time? Get yourself an inventory yourself. Have your appraiser come and appraise it out. After so many years pass, maybe have them reappraise it if you think the valuation has gone up. When you have your insurance company come, have a picture of what you think has value, whether it's the personal property, the real estate, whatever have you. Have these things, put it in the trust, and then, and there's no guessing. But when you don't do that, probate will. That's what probate court does. When you don't write up a will, then they'll make one up for you. They'll find out how much of an effort they put into it. I don't even want to get down to that argument, but they'll find out the heirs that they believe that are the beneficiaries. Once they get those names in order, then they're going to inventory your property. Then they're going to appraise your property, and they're going to determine how much you're worth and what gets dispersed, pay off your bills, like, because of the liens that are on there, they're going to have to pay that out. And then the money gets dispersed out to the heirs. That sounds nice, huh? But guess what? They don't work for free. So while they're doing all the work for you and you're not here to deal with any part of it, your beneficiaries are losing a lot of the money in the valuation, because a part of that valuation goes into what they have to pay the conservators, what do they have to pay the attorneys, how much was the filing fees. All that comes out of the estate. So to avoid being overcharged and paying all those attorney fees and conservators and all that extra stuff, you do it. You do your own will, you do your own trust, get your attorney now, put all your assets, your businesses, your properties, your personal property, itemize those, inventory those out, get the valuations from them based on the appraisals, have the insurance coverage to back them up, put it in the trust, and by all means, avoid 2 to 5, 6, and 8 years. And like I said, 9 years for Prince, 5 years for Aretha Franklin. This one's been going on for Dee Warner for 2 years. Now, she wasn't as famous as Prince. and Aretha Franklin, but she still has a long trust time, 2 years. And why is that? Because there is another side who's not turning things over. So if you do it and you do it now, then when you're gone, your family doesn't have to wait that long. It's 90 days. It's different time. 90 days, 2 years. And 2 years is the normal time for probate. But because Dale Warner is not turning over things to conservators, not giving access to the appraisers, and everything is not necessarily where it's supposed to be because certain equipment is off somewhere else, and he sold this and he put that over there, and da 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 da. You got to go through all this other stuff in order to prove actual valuation and ownership. So I implore you, like, share, subscribe, share this information, share it. This is the tragedy in her disappearance and the tragedy in her demise and most likely death is something we cannot articulate enough because of the children and the family that is left without their loved one, and friends who say that she was the rescuer. What do they call her? The first respondent to their lives. Well, guess what? Maybe that's not your storyline, but you could become a duplicate of this situation if you don't have a will and a trust, because the fur is now missing. The diamond wedding ring is missing. The jewelry that you had that had some value is missing, and we don't know what happened to it. And no one can prove that you actually had it because you didn't have the insurance on it. You didn't do the inventory for it. You never did an appraisal. You didn't put it in a trust. You didn't write in a will who you wanted to give it to in the first place. So avoid that. Avoid all that. Get a will, get a trust. Share this with your loved ones so they know. Will and a trust. All right, I'm on my soapbox for long enough. We've had a long day. It's been a blessed Dee Warner day. Love and respect to her family. And I'm Lyric Armstrong, real estate agent and advocate. See you in the next video. I might take a break because I'm tired. But anyway, hope you're doing well.